This hearing starts like a routine scheduling conference, but it quickly turns into something much bigger. The defense wants the earliest possible preliminary hearing because a key witness has submitted paperwork saying they no longer want to pursue the case. At the same time, the defendant argues he's suffering serious medical problems while in jail. The prosecutor, however, says the case may still move forward even without the witness's cooperation. What happens next shows why speaking at the wrong moment in court can completely change how a judge views a situation. Stay with us, because this hearing takes an unexpected turn.
But the court has received, I guess what's been entitled an affidavit of non-prosecution.
Yes, Your Honor, we were sent a copy of that.
Okay. Do people be ready to go on the 13th or you want the 20th?
Excuse me.
One moment, Mr. Taylor.
Would we be able to have the 20th, Your Honor?
Excuse me.
One moment, Mr. Taylor. One moment. The judge will give you a chance. Your Honor,
Preliminary examination
Honor,
in person will be set June 20th, 2023, 9 a.m. That will be before Judge Fresh Hour.
Your Honor, may I respond, please?
Yes, go ahead.
We believe that the 13th would be the most appropriate date. From the affidavit, it appears to us that it is clear that the complaining witness does not want to be a participant in this. If, in fact, it turns out that there's not going to be a complaining witness, then there's no reason for them to go to the 20th as opposed to the 13th. Normally, they would ask for.
I don't know if they know that. I mean, this is yes.
As this court is very aware, we don't actually always need the victim to go forward with this case. So I would like some time to look into this, to have my victim advocate be able to speak to the victim if possible, and to be able to see if we can proceed without her.
At this point, the defense is trying to persuade the judge that delaying the hearing serves no practical purpose. Their argument isn't only about the witness's affidavit, they're also emphasizing the defendant's reported medical condition while in custody. Even when a witness expresses a desire not to participate, prosecutors can sometimes continue a criminal case if enough independent evidence exists. That's why the prosecution asks for additional time to evaluate whether they can legally proceed. The judge now has to balance fairness to both sides while following procedural rules, making this a critical moment in the hearing.
Tylenol. He was finally able to get a kite put in, and they had to up it to, I think, neoproxen. Is that what it was, Mr. Taylor?
Nortriptyline.
Oh, I'm sorry. Nortriptyline.
It's another one. Naproxen was what they did before. Now they changed it to nortriptyline, and they're supposed to add another pain medicine today, moxilin or something like that. But I haven't gotten it yet.
So he is suffering from serious medical issues while he's in the Washington County Jail. There's every reason to believe that the prosecution will not be able to go forward, even if they say that they think they'll be able to proceed without the complaining witness. Would rather find that out sooner than later, rather than have Mr. Taylor sit in jail with his medical issues for an extra week. This is something that they can expedite given all of the circumstances, given they have this affidavit of non-prosecution, given they have this sort of warning. I believe that in the interest of justice and the essence of preserving judicial resources, and certainly in the interest of not keeping an individual incarcerated for longer than might be necessary, that having them setting this matter for the first available date would be appropriate. This is not an argument I would typically or normally make, but given all of these circumstances, I think it would be very
well. And we don't usually get these, and I might agree with you, except that this doesn't say that the complaining witness, or to the extent that she is, will not testify. All it says is she doesn't want to, but she does understand that she may be compelled to. So I don't know what that means, and I don't know. And I think, in fairness to all sides, because this came in and I don't know what communication has been had with Ms. Taylor or anything along those lines. I'm setting it within the time frame that is
Excuse me.
by statute. I don't think I'm delaying it in any way, but I'm going to attempt to be fair to both sides in regard to it. So it's 12 days out, and that's what.
The judge decides to keep the later hearing date instead of moving it forward. The reasoning is straightforward. The affidavit only states that the witness does not want to participate, but it does not conclusively establish what will happen if the witness is legally required to testify. Rather than making assumptions, the court wants both parties to have enough time to review the new information. It's a reminder that judges often focus on procedure and fairness rather than speculation, even when one side believes the outcome is already obvious.
Okay, but sir, you didn't inform them that she also has a letter that she went through the advocate and placed with the court clerk as well as the prosecution that she will not be participating, that she has absolved herself of any responsibility where this is concerned. She's not going to testify.
Okay, Mr. Brown, first of all, and I'm just going to lay this out, and maybe Mr. Taylor, you should listen to your attorney.
Okay.
Because your attorney is telling you not to say anything to the court. Now you're talking about communications that you're aware of that have been made, or at least purported communications, where the alleged victim says now, unlike the affidavit in front of me, that she will not testify, which I don't know. And I'm not saying that you were interfering. It would be a little bit, I'm a little bit concerned that you know that. And so I think even more so that people ought to have an opportunity to look at this and make sure that it is not by your interference that this is occurring. So you probably should have listened to Mr. Brown and just been quiet, because that was not my conclusion at all until you started talking.
Okay.
So, Mr.
Bond
Taylor,
will continue. Thank you.
that you're going to, that's going to change the ruling that's been made right now. So I would ask you not to make any
You're going to ask for bond, and that didn't happen either. Can I terminate Mr. Brown and request the ability to hire outside counsel from the public defender's office?
Mr. Taylor.
This hearing highlights how quickly courtroom dynamics can shift. What began as a request to speed up the case became a discussion about witness cooperation, medical concerns, and courtroom procedure. The judge ultimately chose to leave the preliminary examination on the later date, explaining that fairness required giving the prosecution time to evaluate the witness's statements before moving forward. The defendant's decision to speak directly also prompted additional concerns from the court, reinforcing why attorneys often advise clients to remain silent during proceedings. While no determination of guilt or innocence was made during this hearing, the case demonstrates how procedural decisions can significantly affect the direction of a criminal case. What do you think? Did the judge make the right call by keeping the later hearing date, or should the defense have received the earlier date they requested? Let us know your thoughts in the comments. If you found this courtroom breakdown informative, be sure to like the video, subscribe to the channel, and turn on notifications for more real courtroom analysis and legal case breakdowns.